Justice Binta Nyako of the Federal High Court seat in Abuja has recused herself from the trial of the detained leader of the proscribed Indigenous People of Biafra, IPOB, Nnamdi Kanu, on the allegation of bias leveled against her by the accused person. The decision of the judge to recuse herself from the trial followed Kanu's open outburst against his counsel and the judge. Kanu, who spoke from the dock at the resumed proceedings, directly told Justice Nyako that he no longer had confidence in the handling of his trial, while his lawyer, Aloy Ejimako, was trying to persuade the court to suspend the trial on the basis that his client was denied the opportunity to prepare his defense. Kanu got up from his seat and ordered him to sit down. The prosecution counsel urged the court to proceed with the trial, but Justice Binta Nyako declined and recused herself from the case.
This is for our client to get fair hearing. And if this fair hearing cannot be guaranteed in this court, then we need to try another court. The Constitution is very clear on this. Section 36 made it very clear that he deserves, as of right, the adequate facility to prepare for his defense. And who prepares him for his defense? His defense counsel. But we're not being given the opportunity. The court did make some order, and the consequences of that order would have resulted in getting him adequately prepared. But most of those orders were disobeyed in their material particulars. For instance, we were not provided a clean room where no one will have listening devices to listen to our conversations. And our documents, legal documents we take to the DSS facility, detention facility, are interdicted and seized and taken to places, photocopies and whatnot. Even anybody who is not a lawyer knows that a client, especially a defendant who is facing the death penalty, deserves to have some private time with his lawyers in terms of preparing for his defense. It's not everything we discuss that is critical to his defense that the prosecution is supposed to know in advance. But this is exactly what was happening in this matter. And then secondly, we do have 3 appeals. One goes to restoring his bail, which the Supreme Court severely criticized the revocation of his bail by this High Court. And the other 2 go to the jurisdiction of the High Court to try him for these offenses. So what is really the essence of rushing to trial when you have these 2 situations militating against such trial? So we took that position and we tried to relay it to the Honorable Court, but the court was insisting, in the face of all this, especially the injustice of not allowing him his constitutional right to fair hearing, the court was insisting on proceeding to trial. That left our client with no choice than to express his loss of confidence in the impartiality of the court. That's what happened. That's why he requested for the judge to recuse herself. Thank you.
Thank you.
Okay, sir. The issue of settling out of
artist leaders and the federal government of Nigeria, and it's our understanding as a legal team that they are having discussions on that. Yes, but our job is to come here and practice law and protect the rights of our clients.
All these things are online, so I suggest that the journalists in this country actually take out time to do some basic research. It's not difficult, just minor research. You will understand the vacuousness, the emptiness of all the charges against me. They kept switching the charges. They said I committed this crime in England, isn't it? Yes. And in 9 charges leveled against me, this place where I committed this crime was London, in the United Kingdom. Yes. When my lawyers came to see me, I had a discussion with them about how I'm going to defend myself. I told them that no court in Nigeria has jurisdiction to try me. Because since this offense was committed in England, so they said, it's only a UK court that can give a Nigerian court the authority to proceed, isn't it? Yes. They charge again and remove London.
Location of the broadcast.
Location of the broadcast. Contrary to section 196?
174 of the Terrorism Prevention Act 2022.
In violation of their own laws. In violation of their own laws. And you want me to stand trial under such circumstances? Is that possible? Nnamdi Kanu to stand trial where all these shenanigans are going on? It's not possible. Those of Biafra are trying to use my name to gain relevance. I don't want it. I don't want any killings, no kidnapping. All this nonsense are alien to us as a people. I don't know where these animals came from. They are taking advantage of the fact that I'm in detention. But it will soon end. It will soon end. On IPOB, trying to use the name of IPOB, trying to subvert the will of the people, our principles and our core values. that person has a lot to contend with when the time comes. You can run, but you can never hide. You can run and hide and be talking all manner of rubbish, but one day we'll catch up with you.